I thank the President. I thank the Majority Leader for his remarks and his leadership. I'm also glad to be here with the Senator from Wyoming, who over the years has been the leading Republican senator on the issue of ambush elections. We're here today, as the Majority Leader said, to introduce a Congressional Review Act resolution to stop a new National Labor Relations Board rule. I'd like to speak about that for just a few minutes and then let the Senator from Wyoming continue. Last December, the NLRB issued a final rule that shortened the timeline between when pro-union organizers ask an employer for a secret ballot election and when the election actually takes place. I refer to this, as many do, as an ambush election because it forces a union election before an employee has a chance to figure out what is going on. Even worse, before an employer has a chance to figure out what is going on. Even worse, it jeopardizes employees' privacy by requiring employees to turn over personal information, including email addresses, phone numbers, shift hours, and locations to union organizers. The effect of this resolution will be to permit the Majority Leader to bring this resolution to the floor after the congressional recess. There will be 10 hours of debate. The resolution can't be amended. It needs a majority vote to pass. The House of Representatives is following a similar procedure. Both houses must vote on it. If it passes both houses, the President can sign or veto the resolution. If he decides to veto, it would take 67 votes to override. If the NLRB's new ambush election rule is disapproved, the board cannot issue a substantially similar rule without congressional approval. Now, Madam President, today more than 95% of union elections occur within 56 days of the petition filing. But under this new rule, elections could take place in as few as 11 days. This rule will harm employers and employees alike. Here's how. If you're an employer who gets ambushed, in other words, a union election happens before you really know what's going on day one, you get a fax copy of an election petition that's been filed at your local NLRB regional office stating that 30% of your employees support a union. The union may have already been quietly trying to organize for months without your knowledge. Your employees have been only able to hear the union's pitch. By day 2 or 3 of this process, you must publicly post an election notice in your workplace and post it online as well if you communicate with your employees electronically. By noon on day 7, you must file with the NLRB what's called a statement of position. This is a comprehensive written legal document in which an employer sets out a legal position. Under this new NLRB rule, you, the employer, waive your rights to use any legal arguments not raised in the document. On day 7, you must also present the union and the NLRB with a list of prospective voters as well as their job classifications, shifts, and work locations. Then on day 8, a pre-election hearing is held at the NLRB regional office and an election date is set. By day 10, the employer must present the union with a list of employee names, personal email addresses, personal cell phone numbers, and home addresses. Day 11 is the earliest day on which the NLRB can conduct the election under the new rule. Under the new rule, the union has the power to postpone an election by an additional 10 days at this point, but the employer has no corresponding power. Under this new NLRB rule, before day 8, an employer will have less than 1 week to figure out what the election petition is, to find a lawyer, legal representation, and Madam President, many employers don't have a labor lawyer as a matter of course, to determine legal positions on the relevant issues, to learn what statements and actions the law permits and prohibits, to gather the information required by the NLRB, to communicate with employees about the decision they are making, to correct any misstatements and falsehoods that employees may be hearing from union organizers. Making even the slightest mistake in this, in the lead up to an election, can result in the NLRB setting aside the results and ordering a rerun election. Or worse, the board could require an employer to automatically bargain with the union. But it is the employees who stand to lose the most under this new rule. First, because of this ambush election, employees may only hear half the story about what unionizing may mean for them and for their workplace. When a workplace is unionized, especially in a state that does not have a right to work law, employees have their dues money taken out every paycheck, whether they like it or not. They lose the ability to deal directly with their employer, to address concerns, to ask for promotion, to ask for a raise. They instead have to work through the union. Important considerations, like which of their fellow employees will be included in the bargaining unit, will no longer be determined before the election. As the two dissenting members of the NLRB put it, employees will be asked to vote now, understand later. Second, employees lose their privacy because the rule that is proposed, now final, the rule we seek to overturn, requires employers to hand over employees' personal email addresses, their cell phone numbers, their shift locations, their job classifications, even if the employee has made it clear he does not want to be contacted by union organizers. This rule, Madam President, appears to be a solution in search of a problem. Only 4.3% of union elections occur more than 56 days after the petition filing. Within 56 days, nearly 96% of the elections occur. Only about 4% occur after 56 days. And the current median number of days between a filing and election is just 38 days. So half the elections are in less than 38 days. These figures are well within the NLRB's own goals for timely elections. And unions won 64% of elections in 2013. In recent years, the union win rate has actually been going up. So, what's the problem here? The majority leader said it very well when he referred to a 1959 debate over amendments to the National Labor Relations Act. And then Senator John F. Kennedy warned against rushing employees into a union election. Senator Kennedy said, quote, "There should be at least a 30-day interval between the request for an election and the holding of election in which both parties can present their viewpoints." The 30-day waiting period, Senator Kennedy said then, is an additional safeguard against rushing employees into an election where they're unfamiliar with the issues. Madam President, it's clear to see that this rule is wrong. And that is why Senator Enzi, Senator McConnell, and I are asking the senator to disapprove it and to prohibit the National Labor Relations Board from issuing any similar rule. I thank the President. I yield the floor.